Welcome back to Safety News. This is Russ Kenzior, and today I'm interviewing a personal injury attorney by the name of Jason D'Souza, who I've worked with many times on quite a few different cases. He's a probably one of the best attorneys, in my opinion, in the country that specializes in matters involving personal injury, which a lot of people just kind of get wrong. They don't really understand what's involved in a personal injury lawsuit, how do you file a lawsuit, and how do lawyers go about representing clients. So I've asked Jason to come into the studio today and talk to us about personal injury law. Jason D'Souza, welcome.
Thanks, Russ. Thanks for having me.
So tell us a little bit about yourself, your background, your area of practice, how long you've been practicing law.
Okay,
sort of thing.
So I was born in Toronto, Canada, and I went to school in Michigan at a school called Thomas M. Cooley Law School. My wife and I moved to Texas in 2009, and I've been a plaintiff's attorney since 2010. I started by representing only plaintiffs, working at another firm, small firm in 2010, opened my practice in 2015, and since 2015, we only represent plaintiffs in injury suits against companies and even what we call non-commercial, so individuals suing individuals, car accidents, slip and falls, oil field, wrongful death cases, 18-wheelers, all kinds of personal injury cases, but we only represent individuals who've been injured.
So how'd you get into law? What motivated you to become an attorney?
Well, when I was in college, my father and I, we had tried to start up a little company, and it was an entertainment theatrical lighting company. And I found that I had a real tough time convincing people that they needed, theatrical lighting. And I thought, I enjoy the law. I like studying the law. I'd done some business classes in college. So I thought, I don't think that lawyers have a whole real tough time convincing people, particularly if you're a good lawyer and you have a need for it. So I said, let me give my a shot at law school. I went to law school, enjoyed it. It was tough, real tough. Got out, and we moved to Texas. And when I moved here, I really had no idea what type of law I wanted to practice, even after getting licensed.
How does an attorney or a candidate for law school make that decision? I mean, you go to law school, it's not easy, it's 2 years. It seems like every attorney wants to, go to work for big companies, big prestigious firms. Maybe that's wrong. You tell me. But, what motivated you to get into personal injury law?
So law school is 3 years, and then after law school, you got to write the bar exam, and that's going to be about 6 months later. So overall, it's about a 4-year process, 3.5, 4-year process. Wow. I wanted to get out of law school and work for a big company also, because I think a lot of law students, they're drawn by the idea of, or undergraduates, law students, they're drawn by the idea of corporate law, working for big companies, lots of money involved, lots of big deals, big mergers, big time type things. And for me, it just wasn't in the cards. So I started working for a small little tax lawyer. He was a one-man operation. And he said, hey, I'm going to give you all of my crappiest cases. The crappiest case I have, no tax law. I'm going to do all the tax law stuff. But all the crap that I have in my office, you're going to work. So I said, well, that sounds like a great deal. I'll take it. Yeah, right. So then we started working there, and one of his clients was, in his tax practice, was an injury lawyer. And that injury lawyer was not in the habit of paying his taxes, which I don't recommend for anybody. But I got to see his books, and I said, hey, these guys are making a lot of money. And I studied, while I was working at more of the plaintiff side. And I said, injury law has a lot to do with medicine, has a lot to do with anatomy, bodily anatomy. It's not just, two cars hitting each other and somebody complaining of, my neck is hurting a little bit and it gets paid out. It's a lot more involved. It's very, insurance is everywhere, as everyone knows. Right. So the possibility of collecting on insurance varies throughout all kinds of cases, and it's highly competitive. I mean, there are a ton of injury lawyers in the state of Texas. There's a ton of injury lawyers in just about every state, but it's a highly competitive field because there are many, many injury lawyers who take cases, and we call them turn and burns. They'll take them, they'll flip them for a few dollars, tell the client, hey, there's not a whole lot we can do, and they'll move on. What I enjoy doing and what makes me as good as I am and our firm as competitive as we are is we take these cases all the way up to the cusp of trial. And we fight them and we fight them and we fight them. And if they're not willing to pay top dollar on these cases, then we'll go try this case. So that to me was a real draw in getting into personal injury and the personal injury angle of work. And on top of that, it's competitive, and you are not guaranteed payment unless you perform well. So it's performance based. Mm-hmm. So if you're not the best, you're not going to win. And if you're not a winner and you're not aggressive in how you represent your clients, well, you're not going to win those cases, and more people aren't going to hire you.
It seems like a really stressful profession. You read a lot about how, various attorneys have just high rates of suicide, drug abuse, that can really be stressful. It seems like a very stressful job. Is that fair to say, being an attorney?
Very much so.
And there might be some areas of law that are more stressful than others.
I believe that. I think I like to give credit to a lot of different industries. I think there's stress found in any number of industries. I think what you do, Russ, for example, is probably quite stressful also. You're running the NFSI here. You've been doing that for a long time, keeping it afloat. Putting pressure on industry to make sure that they make things safer dealing with the government. So I think stress is a matter of perspective. Sure, our industry is stressful. There's a lot of stressful moments. It's a high pressure type business. There are people who I've hired who they want to get into the business because I think there's a possibility for superstardom. But it's difficult because if you don't keep at it, the pressure can get to you and it can cave you.
All right, you brought up the term superstardom. How do you go about, as an attorney, building your practice? How do you get clients? How do you grow your enterprise?
Well, in 2015, I started my practice. So this would be our 9th year in business. And one of the things that I focused on was just focusing on certain counties in Texas. So I was lucky enough, I had a paralegal, and she is from a small little county south of San Antonio called Duval County. Duval County has 3 cities in it, Freer, San Diego, and Benavides. And Duval County is a very, very, very friendly plaintiff's venue. Because it's so friendly of a plaintiff's venue, though, they fight like hell. Those defense lawyers and those insurance companies, they fight like hell. But when push comes to shove, at the end of the day, they will pay out. Now, what I did is I focused on Duval County and its neighboring county, Jim Wells County, which is where Alice, Texas is, ALICE. Mm-hmm. And I just focused my marketing efforts in those small counties, and I would go down there and I'd meet people. I'd personally sign cases. I'd drive down there. I was there, once a week, shaking hands, talking to people, getting referrals. So we built this practice largely on a referral basis. Now, personal injury is very, very difficult, in my opinion, to build as a practice because we only get paid when the case settles. So you're going to go without a paycheck for a year, 2 years, 3 years, 4 years.
A lot of people don't know that, Jason. They think, this is a get-rich-quick scheme. These lawyers make all this money. They don't necessarily realize that when you take on a client, it's your money out of your pocket. I mean, you're fighting for somebody that if you don't get something at the end, you don't get something. And there's been quite a few attorneys that spend millions of dollars. I'm preaching to the choir. The cost, but they don't always get the outcome they want. And then if you want to go to the appeals process, right, that becomes even more expensive. You mentioned San Diego, Texas, which you and I worked on a case in San Diego. You may want to tell our audience exactly what that was. That was one of the really one of the most interesting cases that I worked on because of it was very, very simple. And I was really surprised it even went to trial. I don't know if you did or not, but it seemed like a fairly simple, straightforward case that, was I there for like 2 days? They called me back twice to testify, if I remember correctly. But tell our audience about that case. That was a fascinating case.
So my client, his name is Roy Canales. Very, very nice man. He lives in Freer, Texas. San Diego is the seat of the county of Duval County. Now, Roy was in Freer. And what he was doing is he was there on a hot summer day buying a watermelon for himself. Roy, when the incident happened, he was 69 years old, and he was a pumper gauger in the oil field. When you work in the oil field, or anybody who works in the oil field knows, you're wearing steel-toe boots. So what happened is he walked into the store. About maybe 20 feet into the store was the watermelon stand. The watermelon stand, the watermelon box was held. There were 3 of them, and they were on 3 pallets. So he reached in, he walked up to the box, reached in, went to grab himself a watermelon, pulled his foot away, but unbeknownst to him, his other foot had gotten caught underneath the pallet. And he fell backwards, shattered his elbow, and twisted his neck. 69 years old. Now, he got up, was holding his elbow, walked over to the cashiers, and told them what had happened. One of those cashiers remained on her phone the whole time. The other cashier, it took her about, on the video, it was about a solid minute. It was about, I think it was 1 minute and 6 seconds on the video. And that's how long it took for her to take the lollipop out of her mouth before she began writing down, not in an incident report, just on a scratch piece of paper that she could find, what had happened. Didn't call 911 for him. Didn't report it to her manager, didn't do anything. In fact, his wife had to come get him and take him to the hospital. And then at the hospital in Alice, they couldn't treat him. So he had a friend come pick him up and take him to Audie Murphy Hospital in San Antonio. So at any rate, that case went to trial. They offered us initially at mediation $100,000. And we said, no, absolutely not. The man had a elbow surgery, an ALIF on the elbow, an ORIF on the elbow, not an ALIF, ORIF, and he had neck surgery. ORIF is open reduction internal fixation surgery. Had a neck surgery also. They offered us $100,000 in mediation. The week before trial, they offered us $150,000. Well, we got to trial, and it was a 2-week case tried in July of 2019 over the July 4th holiday. So we started trial on Monday, went until, I want to say Thursday. The following week, that weekend was the July 4th holiday weekend. We reconvened on Tuesday. So when we left, I wrote them a demand letter, and we wanted to settle for $1 million. Because that trial, that first week was not going well for them. Settled for $1 million. We gave it to them as soon as we had that first week break. And I said, it expires when we return for our second week of trial. Well, we got back to the second week of trial, and the defense lawyer started cracking jokes first thing that morning. And I said, you got the $1 million ready? And he said, oh man. He goes, I left my pen in the car. I was going to write you a check, but I left the pen in the car. Okay, no problem. Tried the case. Later on that week, the jury came back, and it was a 2-part verdict. They initially awarded us $7 million for compensatory medical damages, and then they awarded us $13 million for punitive damages. And I'll tell you that after the first verdict, the $7 million came in, it's like that defense lawyer had been knocked out and was on the ropes. He couldn't think straight, couldn't speak straight. And within about an hour, after the first verdict came in, I asked him, do you want to settle this case now? Do you want to talk now? Right? He said, no, I got nothing to talk about. I said, okay. Went back, and jury hit him for another $13 million.
In punitive damages. So for a total verdict of $19.3 million. Holy cow. Well, I distinctly remember testifying at trial. It was before the 4th of July. And my testimony, as I recall, was very straightforward. The case was involving a pallet. And if I'm not mistaken, there was some surveillance video that they took, but then there was like a big edit in the middle. Like they showed him coming in, then they showed him like on the ground or something. They missed a whole part of the surveillance video. It was an odd edit, which was denied. But my entire testimony was pretty straightforward. It was, pallets are not displays. And if you're going to use pallets as displays in a grocery retail store, that's fine. Just make sure you cover the bottom of the pallet, because people can get their feet stuck in it, like Mr. Canales. And, kids can maybe brush across it, get slivers or a nail sticking out. So it's very, very straightforward. Just put pallet skirts around the base of the pallet. That's the industry standard. They're inexpensive. They're used all over the place. In fact, I noticed them being used a lot more since your since your case, went through. But that was my testimony, and I distinctly remember. And I, of course, having worked on over 1,300 retentions, I distinctly remember just kind of being bullied. I don't know if that's a fair statement, but I really felt that it was such a simple case. It was not hard. There was nothing threatening about my testimony, but I just kind of felt like they overreacted or over-responded, and it was a bit, startling. And I remember, well, Mr. Kenzier, you stayed in Alice, Texas the night before. Did you notice there was a Walmart across the street from Alice, Texas? Remember this testimony?
I sure do. And what I think you're correct about is that they went at you real hard. We had initially planned for your testimony to last just the afternoon, which is very typical for an expert witness when they come live, or a doctor, or that type of witness. Generally, we only plan for an expert to come for a quarter of a day. But you were there the entire afternoon. They went at you real hard. They objected a lot during my examination of you. And I think part of it was they just wanted to harass you, Russ, and they had to hold you over. And I remember, you telling the judge, well, hey, look, I got to be in Los Angeles the next day, and I got to testify at trial in LA tomorrow. And the judge said, well, Mr. Kenzier, tell me what you need to give that court in LA an excuse. And you said, well, I think I need a court order. Right. So the judge said, Mr. D'Souza, go and prepare a court order, have the defense lawyer review it. And he signed off on it that day, and they continued on you the next day, the next morning. Yeah.
It was weird because it was a 4th of July holiday. Uh-huh. And so it just was so long. And I guess the word, came at me hard is probably an understatement. It was very aggressive. But my position was pretty simple. I'm not a plaintiff advocate or defense advocate. I'm a safety guy. And this was a simple case. But I remember, Mr. Kenzier, across the street from your hotel was a Walmart, or I forgot what it was. Did you happen to go in there? Yeah, I did. It's a small town, not a lot to do. And did you notice that they were not wearing or using these pallet skirts? The plastic skirts that go around the base of a pallet. And I said, well, yeah, I did notice that they weren't using pallet skirts. Well, on your way to trial, did you drive by an H-E-B grocery store? Yeah, I think that was closer to San Diego. Yeah, I did. And did they have pallet skirts? No, they didn't have pallet skirts either. And so, well then, Mr. Kenzier, you would agree that pallet skirts are not really the standard of care. I don't know if you remember this, Jason. And I said, well, it depends where you live. I said, I'm from South Lake, and South Lake's a very wealthy community. And we have Walmarts, supercenters, and grocery stores in our area, and they all have pallet skirts. But we're in San Diego, and this is a poor community, underprivileged community, and they don't get safety. And I'll never forget, just looking at the judge and the jury, that resonated. They understood that people that have more money get treated differently than people who don't. And it was just the unfairness of that case, Jason, that really still resonates with me to this day. Now, where are we at? Where are you at on that case? What happened?
Well, if we go back a little bit, I think you're exactly right. What resonated with the jury is that safety's for everyone. Safety doesn't get distributed by the amount of dollars in your pocket. Safety gets distributed for everybody and evenly. And I think a lot of people in Duval County, at times they feel taken advantage of by the oil field companies or by the big companies that are down there, who feel that they can use them for their labor and take them to the various oil field sites. And once their people get injured, they're discarded. And I think what really resonated with them is their feeling toward these companies who say, yeah, up in Dallas, they've got nice stores up there and they have the pallet guards. I had another expert that came in. He came from Los Angeles. And in Los Angeles, they did use the pallet skirts and the pallet guards a lot more. In closing, one of the things we did is when I put the corporate rep on the stand, they said, well, these pallet guards are just too expensive. We put these pallet guards in all of our stores. It's just too much money and it's going to take too much time. So in closing, I showed the jury the pallet guards, and I showed the corporate rep, during the case, these pallet guards, and we established the price, and we established how quickly it would happen. And in my closing, one of the lawyers I was working with assembled the pallet guard. Now, these pallet guards cost about $80 from Amazon. And we timed it, and it wasn't rushed. And I told this associate, I said, hey, come on up here and put together this pallet guard, and we're going to time it. You know how long it takes to put on a pallet guard? for the second time this lawyer's ever put it on in his life, it took 2 minutes. 2 minutes. So somebody who puts pallet guards on in a store on a regular basis, it would take 30 seconds, right? So you're right. What they didn't like was the fact that safety was being distributed by the fact that they are less economically privileged than other places, say North Texas or San Antonio or Houston or Los Angeles. And they want to send a message. And the second thing is they want to send the message that we in Duval County, our voices can be heard also. Our voices are equally as important as people on the West Coast or people in New York or people in North Texas. And I think they did. And they set that example. And then I'll tell you that immediately after this verdict, the defendant, Pay and Save, found pallet guards and they started using them. Now, in terms of what's happening with the case, it went up on appeal, and it was not a good appeal for us. We lost on appeal. But the appellate court, they remanded the case back to the trial court. Remand just means we're sending it back down. That, however, was not good enough for Pay and Save. So what Pay and Save is now in the process of doing is trying to get it up to the Supreme Court of Texas from the Fourth Court of Appeals, because they want to drive a stake directly through the heart of this case. I don't really have a whole much of an opinion on it. I don't think our appellate lawyers have much of an opinion on it. But I think the simple fact is, if you use any common sense and apply it here, is the appellate court's already done its job. I don't really know what more the Supreme Court has to do. Again, justice is for everyone. And if we have to retry this case, we will retry this case. And I've told the defense lawyers, I've told the insurance company, I've told the defendants, I will go back to court and I will try this case against you every year for the rest of my life until I'm dead, until one of us is dead. And we'll just keep getting verdicts against you. Win or lose, we're just going to keep fighting, and we're going to keep going at you. Because my client, Mr. Canales, is too important to me to just back off with them. And I don't want to stop fighting them, and I won't stop fighting them.
You know, that's, again, one of the personal attributes that you and frankly, Jason, a very few number of attorneys that I've worked with really have. That you're going to fight for your client, and those of us who act as independent experts, we're not advocates. We're there to just bring clarity to the trier of fact, the jury. And in this case, like you mentioned, it's a pallet skirt. It's a piece of plastic, goes around the base of the pallet, dresses it up, makes it pretty so it looks attractive, and you can't get your shoe or boot caught in between the pallet because it's covered. It's really a very simple case, but it just seems like it evolved into, well, you used the phrase, kind of drive a stake through your heart. Is there something bigger going on with this case? Is there an underlying motive that might be, let's do away with these types of cases, entirely in Texas?
I mean, it's hard to speculate for what the defendants are thinking. But if I were to put myself in their shoes, generally speaking, I think that they believe that if these kinds of cases continue to have runaway verdicts, their concern is everyone around the state of Texas is going to start slipping and falling everywhere. I think that's absurd. I think it's insulting more so. And I think that it takes away from the real injuries that people experience. People don't get injured because they are trying for some sort of get some sort of payday, right? That's the boogeyman. That's something that is a ghost, and that's something that the insurance industry has propagated throughout this country, and frankly, even around the world, to have people believe that people just get into these accidents, they hire these lawyers because they're in it for a payday. I could certainly tell you there are a very, very, very small segment of people who are frequent flyers in this business. I have no interest in representing those types of people. Mm-hmm. But the vast, vast majority of people that I have represented, it's the first time they've ever really been injured. They don't like the disruption to their lives. They hate it. They're the first people who really dislike the disruption to their lives. It disrupts their, if it's a car accident, it's disrupted their ability to go to work and drive. It's disrupted their ability to take care of their families. It's disrupted their ability to earn a living. It's disrupted their earnings. for slip and falls, premises cases, it messes with people psychologically because now you don't know where the next landmine is going to go off. And I mean landmine because you're walking through a store and these are places where you trust. You go into a Kroger's, you go into an H-E-B, a Walmart, you go into your convenience store. You're not thinking that there's going to be slime on the floor in the automotive aisle. You're not thinking that the rug at the entrance of the Walmart gas station is going to be crinkled up and you're going to take a faceplant through the door. You're not thinking that you're not thinking any number of things, that there's going to be construction in the store and you're going to go and trip on these wooden boards that the construction company has left on the floor. It's difficult for people, and they are these landmines, and the average person, they don't want to think about that. They want to think about getting their eggs and milk and ordering, whatever they need to order and continue going on with their lives.
Right. I remember a number of years ago, I was working on a case in Florida against a very large grocery store chain. And one of the questions I asked, information that could be provided to me that I could rely upon as a basis of my opinions, is previous incidents. How many previous individuals were hurt, slip and fall in this grocery store chain. And I'll never forget the pushback. Oh, we don't want to produce that information. Well, it's irrelevant to my opinion, because how many people are falling? You mentioned the point about, if this law passes, if this case goes through, all these people are going to be slipping and falling all over. Well, I just wanted to know how many people were slipping and falling in this particular grocery store chain, pretty good-sized chain out of Florida. And finally, a letter came in to the courts that was written by their head of safety for the chain, and they said over a 5-year period at our chain, they had 600 grocery stores. We had an estimated 68,000 claims. That's reported claims, not lawsuits. 68,000 people that they knew of slipped and fell and reported an injury. Again, not lawsuits, just injuries. Well, statistically, for every person who completes a complaint, there's going to be 23 to 40 people that fell and got up and left you never even knew about. And
Absolutely.
So, putting some scale, putting some measurables for the benefit of the jury to understand just how big of a problem it is. In other words, Jason, there's already a lot of people slipping and falling. You just don't know about it. The general public is unaware of how big the crisis is. In fact, I was looking at the data the other day. According to the Centers for Disease Control and U.S. Consumer Product Safety Commission, last year, in 2020, 42,000 Americans died as a result of a fall. 8 million go to the emergency room as a result of a fall. Most of those are slips and falls. It's a big problem. It's a very, very costly problem. And it's estimated that the retail grocery store industry spends about $1 billion a year just on slips and falls. That's how big the problem is. But what I found, and especially in my work outside of my consulting work as an expert witness, but before the NFSI, is the average person is totally unaware of how big that risk is, how common this problem is, how many people get hurt, how many people die as a result of these injuries, and would rather just say, well, it's that trial attorney, it's that ambulance chaser, it's that, stigmatize the victim, slip and fall lawyers. I mean, just look at what the attacks are to your industry, Jason. And how do you deal with that? How do you, when you introduce yourself and you talk about your work as a personal injury attorney, and people roll their eyes, or juries, oh, why am I here? I mean, there's a stigma. Am I right?
You're absolutely right. There is a stigma, but frankly, it's not a stigma that I have any interest in. I don't care about it. I'm not interested in the stigma. If that's an issue that a potential juror has with them, then that's their problem. There's also people who, they may fall on various ends of various issues, and they're welcome to roll their eyes. They're welcome to take positions on it. But one of the things that I always tell myself, and me and my wife joke about, is that you can be anti-plaintiff lawyer and anti-ambulance chaser, and everybody else's claims are BS and crap until it happens to you.
Yeah.
And once it happens to you, hey, this is legitimate. This is a real thing. My injury is actually real. All those other people you represent, I mean, they're probably fraudsters. But me, I really got hurt, and I'm really in a lot of pain.
I mean, I can't tell you how often I hear that. And again, not just in my work as an expert witness, but outside of it, working for NFSI, just communicating the subject matter to people who just don't take it seriously. And even on my YouTube channel, people, some of the comments, derogatory comments, like, don't you have anything better to do? Or, dude, you need to get a life. And I'll always reply back, honestly, well, my life is helping to protect people like you. And I take that seriously. I'm not trying to be cocky. But, when you give a damn, it shows. And when you try to protect people from, unwarranted harm, what's wrong with that? But you're right. It's always somebody else's case is fraudulent. Mine is legit. And especially when they do get hurt, who is the first person they call? If it's a serious injury, debilitating injury, or fatalities, I work on many of those, is that personal injury attorney. But they've done a really good job, our media, that's when I refer to they, of just creating a stigma. I do a lot of media work. In fact, we have a big symposium coming up. You're invited. The end of this year, September. The NFSI is hosting its second international symposium, and our keynote speaker is John Quinones from ABC News.
That's
what would
right.
you do?
Yeah,
I've been on his program, and he may do another program. But his message is the media doesn't always get it right. While they're putting out stories about tonight at 10, woman caught on video pouring water on the floor at the local grocery store chain, staging a slip and fall. Look, Jason, everybody has seen that story. I don't care what part of the country you live in. You've all seen the story of fraud, slip and fall fraud, con artists. But keeping in mind that less than 5% of slip and fall claims, let alone lawsuits, are considered fraud, and that's the insurance industry statistic. That means for every video you see on primetime television showing a fake injury, there's 20 legitimate incidents. But you never see those. You always see the message being drummed by the media of fraud, fraud, fraud. And I've come to the conclusion that this is really part of corporate America's approach to reduce costs by persuading, a would-be one-day juror who's called a trial for a slip and fall to believe that they're fake, they're not real. So it's a way that you can really sway a potential juror into thinking this is all baloney. Because I don't know how else you explain the massive campaign that, since I've been in this industry for almost 30 years, against victims of slips, trips, and falls. We don't see that with any other form of injury. We don't call, out people who, had a hand cut off, in an industrial workplace injury, or electrocutions, or just going down the list of potential injuries. We don't call those people out and belittle them and humiliate them. But I think the real reason why, Jason, and I'm curious what your opinion would be on this, is it's because they know it's a big problem. They know it's a massive, very, very costly problem, that if the truth really did come out to the public, that it would be a tsunami. In fact, I've been waiting for the day, and I'm going to ask you this question. Manufacturers of floors and footwear and even cleaning products, they are creating products that make floors slippery or dangerous. And when you go to buy, a pair of shoes from the store, some of them are labeled slip resistant, most are not. There's just the wild, wild west of safety when it comes to products. And so I'm anticipating the day, and I don't know if it's going to happen, but I kind of feel it is, that there's going to be a class action lawsuit against a particular industry. For example, the flooring industry. You're making products that are slippery, have a high risk, but yet you sell them to mislead the consumer into thinking they're all safe, because after all, and I can't tell you how many times I've heard this, Jason. Well, I'm at the big box retailer and I bought a floor. Well, obviously it's safe, otherwise they wouldn't sell it. I mean, people believe that. People really do believe that because it's sold, it must be safe. When in fact, that's not always the case. But where do you think this is going? Where do you think the personal liability lawsuit, specifically for slips, trips, and falls, is headed? I mean, how big of a deal is this going to be in the future?
Well, if I could expand it a little bit, I think that in the insurance company's bag of tricks, they actually do blame the victim in a number of cases. In our oil field cases, the first person they point to is the oil field worker. In car accident cases, the first person they point to is the person who is the plaintiff. In trip and fall and premises liability cases, which is what slip and falls are, they're called premises liability. First person they point to for the injury is the person who slipped and fell. Death cases, same thing. 18-wheeler cases, same thing. It's the insurance company's bag of tricks. And in that bag of tricks, one of the things that they pull out is called contributory negligence. You, plaintiff, contributed to your own injury. Another thing that they pull out from the bag of tricks is causation. There is no way that when you slipped and fell at that Walmart that your disc herniated. You, 36-year-old construction worker, has been working in bricklaying for 20 years. That's how your disc herniated. That's why you have a bad disc. Even though you've been working in this industry for 15, 20 years now, no problems, no incidents, no reports. Even though you've been a truck driver for 10, 15 years now, even though you've been a nurse, even though you've been, an admin doing your job, all of a sudden, when you get injured here, it's just a coincidence that you're back and you have all these herniations in your back. It's just a coincidence that you tore your ACL. It's just a coincidence that, or it's your fault that your thumb got severed in the oil field. Right. And it's part of their bag of tricks. And another issue of their bag of tricks is, they say this wasn't really our fault. It was somebody else's fault. It was somebody else who was involved in some remote, strange way, and it's their fault. It has nothing to do with us. It has everything to do with them. So where I think it's going is what's interesting is I think if your audience were to Google the phrase nuclear verdicts, nuclear verdicts are generally verdicts which are $10 million and above. And the frequency of nuclear verdicts and the volume of nuclear verdicts has increased largely in the last 10 years. So I think what's happening is, I think it was the late 80s or early 90s was the McDonald's hot coffee case. And that was just their harbinger for industry to go out and say, hey, everyone's a faker. This lady went and got, millions and millions of dollars at McDonald's because her coffee was too hot. Well, let me tell you something. You look into that hot coffee case, and that poor old lady had severe burns to her genitalia. There is no reason that coffee should be that hot, and there is no reason that McDonald's should have been serving that hot coffee. And the number of prior claims of that hot coffee was through the roof. So, they had their McDonald's hot coffee period, but I think that the public now, in the past 10 years or so, is starting to wise up. And they're starting to realize that these are all lies, that these, multi-billion-dollar companies and their lobbyists and their media and their paid media is putting out there.
Yeah, propaganda.
And it's propaganda, absolutely, and it's all for increasing insurance companies' bottom line. Their bottom line. I think the same thing happened in medical malpractice in Texas. And what happened, in 2003 is they put on a scare campaign in Texas. And they said, these plaintiff lawyers, they're going to continue suing these doctors. And before you know it, we're not going to have any doctors left. So what we need to do is remove all regulations on doctors, prevent plaintiff lawyers from being able to sue them, because then what's going to happen is we're going to have more doctors in Texas. Well, let me tell you something. My office, and I'll bet you every plaintiff's attorney's office in Texas, we are overrun with phone calls because doctors don't care anymore. There's a lot of doctors that they don't have that thing in the back of their head letting them know, hey, I can get my ass sued off right now if I don't take care of this old lady. I could get sued to kingdom come if I don't do a proper procedure in the OR today. So what's the value of insulating these doctors when the incentive is getting less safe doctors? Right. And if we apply that to slip and falls and flooring, what's the value of not protecting people and allowing, no regulations on flooring and limiting the ability for a victim to recover if the end result is we continue to have more and more and more injuries and we're protecting unsafe companies? Is that what we want? No, we don't want that.
Sadly, I think that's where we've been, and it's probably getting worse, not better. The business model, Jason, for corporate CEOs, the Harvard Business School teaches the leaders of these companies, in great part, it's a cost of doing business. If people get hurt, okay. It's like, lawsuits are up, premiums go up. We just pass it along to the consumer, right? You pay a little bit more for the food and services you consume because of the cost of injuries, the cost of doing business. Kind of like electricity. An electric bill went up. Yeah, nobody likes that. But what are you going to do about it? So you just pass the cost along. And so I always ask the question, and in fact, in the case in Florida I was talking about, one of the questions that came up was, well, how does the grocery store industry address slips, trips, and falls? And one of the comments that was made, which was really quite striking, is, well, we passed the cost along. They agreed. We passed along the cost of these injuries to our customers by raising the prices of bananas. Did you ever hear this? I wrote this in my book. And that caught me by surprise. And what I come to find out is, I don't know if you knew this, but the number one product by volume grocery store sell is bananas. And most people don't really pay attention to what the price for bananas is. Is it 42 cents a pound or 58 cents a pound? And come to find out, that's how they pass the cost of that lawsuit along, is raising the price of bananas. Because, a couple weeks worth of sales at a 10 cents a pound more, no, you're making leeway. And so the business model is really kind of, I don't want to say anti-safety, but it's not based on investing in prevention. It's based on mitigating risks and simply passing those costs along to the consumer. Ultimately, we all pay a little bit more for the Happy Meal at McDonald's, for the losses of the company. And again, that's no secret, but I think the average person doesn't really understand that part of the reason why costs have gone up is because of injury costs have gone up, litigation costs. You mentioned nuclear verdicts. I read a study that was published by Liberty Mutual Insurance that said nuclear verdicts are going through the roof. And the top two reasons why Liberty Mutual identified for nuclear?
I'd love to know what they think. Yeah,
you can Google it. Liberty Mutual found that the number one reason why jurors were giving very, very large jury verdicts is because, number one, they dislike, some may argue hate, the insurance industry. And they believe that there's an insurer behind this somewhere, even though, as you know, you can't talk about insurance during a trial. But number two, most jurors really hate corporate America. They hate companies. They hate big companies. So if a big company gets dragged into court and there's an insurance company representing them, those are the two formulas, recipes for a potential big jury verdict. And that may have affected your case, in fact, is just that we're tired of being bossed around and pushed around and mistreated, by the big corporations, and insurance companies are some of the biggest corporations. And people get angry. The average person's only opportunity to kind of get back is when they're on a jury. I mean, I don't know if that's a fair statement or not, but that's when their voice gets heard. You know what? I'm tired of all this. I'm tired of being mistreated. I'm on a jury now. Just yet another example of, a corporation taking advantage of a person, or a corporation taking advantage of a person. And by golly, this is my opportunity to send a message to them. And that's where these punitive damages come in, right?
Well, absolutely. And it's interesting because we tried a case. We went to trial last March, and it was against Allstate. And while we were picking the jury, that's called the process of voir dire, one of the panelists, we asked the entire panel, what are your feelings toward this defendant? And we were suing Allstate directly. Excuse me. What are your feelings towards Allstate? Well, one gentleman put his hand up and he said, well, I went to buy something from eBay, and I bought it off eBay, and I bought the insurance from eBay, and it was through Allstate. And this thing broke down in like 6 days. And when I went to make my claim, process my claim through Allstate insurance that I bought on eBay, Allstate told me to take a hike. And he said, I don't know, this thing was maybe $12, $13. Well, somehow the defense lawyer let him slip through the cracks. And you know what? He was the panelist. He was the foreman on our jury.
Wow. And
he led that jury to a $350,000 verdict against Allstate when we had about $19,000 in medical bills. So, the insurance company, they are bottom line driven. and they will not do the right thing. And they think that karma will not follow them. But the fact is that when you do the right thing for people and you don't treat people like cattle, they'll feel fine and they'll be treated fairly. And they think that this is not catching up to them, and it has caught up to them.
That's another interesting point is, jurors are made of, peers or peers, societal peers. Some of them work for big companies, some of them don't. They come from all walks of life, and that's the best jury, right? The best jury is the juror that's truly impartial, and that's the key. I mean, I take that seriously in my work as an expert witness. I'm not here as an advocate. It's simply communicating the information that a trier of fact, a juror, wouldn't necessarily know. That's the only real reason for an expert. I mean, it's, I can't tell you how many times I hear, well, Mr. Kensier, you're just citing a standard. Well, the jury can read that standard for themselves, right?
Just calling balls and strikes. That's
right.
it. Just calling balls and strikes, being independent, fair, and impartial.
Right. Just keep it down the middle, and you don't get into trouble, and you do your job. And let the chips kind of fall where they may. But that's not always the case. And before I let you go, one more question. How do you go about screening cases? How do you know which cases are, worthy of you investing your time and resources, money, and what cases you say, I'm going to have to pass on this?
Well, I think at the beginning of this podcast, we talked a little bit about personal injury lawyers. We have to vet cases. Cases are an investment that I'm making in my law firm. And there's about 7 other lawyers that work for me. I got about 20 to 25 staff, people altogether in my law firm in San Antonio. We're a small law firm. I like to keep it small. And part of that reason is that I want to make sure that we have, quote unquote, good cases. Okay. So what does that mean? Number one, when we get phone calls to our law office, our firm, and they've been referred, I need to know if that person's been injured. Now, if a person's not been injured, then I tell them, hey, look, I know you got into a car accident, or I know you slipped and fell, and they didn't treat you fairly, or the adjuster didn't talk to you nicely, or the other driver wasn't fair, or you've got an older car and they've totaled it out and you need that car. If you're not injured, I can't represent you. Number one. Number two, if you're not injured and you then say, well, it's fine, I could still go and talk to your doctors or get some medical or whatever, that's a flag. You're immediately cut off. So you've got to be injured. Number two, what I ask is, we talk to them a little bit, they'll tell us what happened. And I will ask them, or my intake department has been trained to ask, well, whose fault was this? Who do you think is at fault? Because, like I said, the insurance company's bag of tricks is contributory negligence, number one. Number two is causation. How did this cause the actual injury? And who's at fault? So I will have them explain in their own words, if, for example, it's a slip and fall, and if, for example, they're walking down an aisle at Walmart and there's some slime on the floor, why didn't they see it? What were they looking at? How did the slime get there? How did they determine that it was there and it was put there? How long was it there for? And where in the store, in proximity to employees and employee stations, was that slime? If you're in the middle of an aisle, you're between the men's and the women's clothing section at Walmart, and there's not a lot of traffic going through there, and you're far away from a change room, you're far away from the jewelry counter, you're far away from the cash registers, well, the notice requirement in premises cases is very tight, meaning that was the store or could the store have actually been on notice of what was going on here, right? So that what I want to know is, who do you think is at fault here, right? Are you driving along and you got into a road rage incident with somebody else and you guys then bumped cars? Because I think that in truth, there's going to be more fault than I really care to get into. It's my responsibility to vet cases for the firm. It's my responsibility to make sure that people who are working on cases are making good money at my law firm. I take that personally, and I take it as my personal responsibility.
So you have to do a lot of investigation up front.
Well, we want to
screen.
We want to know. It's my money. It's the firm's money, and I want to know whether this firm's money is being put in a good case or a case that it doesn't really have that kind of potential. And unfortunately, what that means is, we have to decline some cases. We're not going to take some cases. There's going to be things that we're just not going to accept, because the simple fact is, when you are fighting an insurance company and a team of defense lawyers and they're just going at you, it has to be worthwhile to be able to present that to a jury and go all the way. And if we're not willing to go all the way on a case, and if my plaintiff, my client, isn't willing to get all the necessary medical treatment that their doctors are recommending, I don't know that that's something that I could really accept. And the final thing that we always look at, I'm sure that the defense lawyers and the insurance industry will love hearing this, but one of the things as plaintiff lawyers we have to look at is a case is sometimes like a slot machine, okay? And it's my job to get clients the most money. So slot machines are 777, right? You get 3 cherries, boom, you win. So liability, number 1, who's at fault, is the first cherry. Damages, number 2, do you have sufficient injuries to actually collect a substantial amount of money, is the second cherry. And the third one is collectability. If you are assaulted by your ex-girlfriend in a parking lot, unfortunately, I'm willing to bet your ex-girlfriend is uncollectible, and we can't really get any money out of her. So we have to make sure that we've got all 3 sevens, all 3 cherries of that slot machine lined up, because that's how we do the best job for the client. And the biggest thing, because I think a lot of people don't understand, or they may not be aware of this, is my firm, and I think a lot of plaintiffs' firms, the vast majority of them, we charge no fees, we charge no expenses, and we advance money to clients for their living expenses. So if that case goes south and we don't prevail at trial, well, you don't get a bill from me for, we could rack up hundreds of thousands of dollars in attorney's fees. You don't get a bill. I will regularly put in between $50,000 and $250,000 in case expenses on big cases and commercial cases. I will also advance to clients living expenses. That could be $1,000 to $3,000 a month over the course of 2, 3, 4 years sometimes. That's a lot of money. But what I want to do is make sure that their family is not going to go under, is not going to go bankrupt, is going to be able to get what they need. So we have to make sure that a case is viable, that we're going to collect, and that a client is going to do what they need to do to address their injuries.
How often do you get a client that may not be that ideal client?
All the time. All the time.
Yeah, well, you never. What is it? You can't pick. You can pick the jury, but you can't pick your clients, or however that goes.
Well, they say you could pound the facts when you don't have the law on your side. You could pound the law when you don't have the facts on your side. And when you don't have neither, you pound the desk.
Well, that's a good way to end this interview. Jason, appreciate you coming up. Jason D'Souza, tell folks how they can reach you.
Okay, well, my name is Jason D'Souza. You can contact me directly. You can call me on my cell phone. It's 210-591-9777. I own an injury law firm in San Antonio, Texas. You can email us. You can go to our Facebook page, which is D'Souza Injury Lawyers. You could find us online, which is D'Souza Injury Lawyers or D'Souza Law. You could text me. If you really want to get a hold of me, the best way to get a hold of me is texting me. Unfortunately, the phone calls just don't stop with me. I'm always in different places right now. After this podcast, I'm going to look at my phone. I've got like 8 missed calls and 40 text messages. But if you want to talk to me and you want to know what's going on and you want to run something by me, if you have an injury, text me. And my cell phone number is 210-591-9777. And I'd love to find out what's going on with you. And I'm happy to give you my opinion. And if you've got a case and it's a good case, I'd love to represent you.
Well, there you have it. Jason D'Souza, D'Souza Law Firm, San Antonio. Appreciate you coming up today and educating the audience about the realities of personal injury law, how these cases are screened, how they're managed. And, not everything always works out for the best. But I think it's just really educational for people. Jason, I've heard your message today and appreciate you coming out.
Yes, sir. Well, thanks for having me, Russ. And thanks for inviting me. And I look forward to seeing you in September.
Yeah, the symposium.
Yeah.
Well, we now that you got that on the record, we expect you to be there. So, Jason D'Souza, thank you very much.
Thanks, Russ.
Take care.
All right.